going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great day so far. Happy Wednesday. Happy Hump Day. It is Wednesday, right? Yeah, it's Wednesday. Why did I just get confused? I think it's Wednesday. We're going to pretend it's Wednesday if it's not. All right, anyways, let's get to it. I've got some court. Weird, right? I got some court. We're going to start with Judge Washington. Got a little bit of a heated hearing in front of Judge Washington. The attorney kind of comes in, let's just say brash. Let's use that word tonight. And yeah, well, I'm not going to spoil it for you. And then I've got two small clips to round it out, to round out the evening. But the Judge Washington clip will take the majority of the night. It is about a 30 to 40 minute clip, but it's a good one. It's a good one. All right, you guys ready? Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Ypsilanti Township versus Nicholas Jones, 24T00166.
Paul Barnett on behalf of the township.
Good morning, Your Honor. Gabriel Lacey on behalf of Nicholas Jones.
Good morning. Mr. Jones, please state your name.
Yep, Nicholas P. Jones.
Thank you. All right, we're here today for a bond violation hearing. Motion to dismiss and a motion to withdraw plea, correct?
That is correct, Your Honor.
Guess we should start with the I guess we'll start with the motion to withdraw plea first. Are you prepared to proceed on that today, Mr. Burnett?
I'm sorry, were you asking me?
Yes.
Yes.
Okay. All right. Ms. Lacey, you may begin.
Thank you, Your Honor. Yeah, at this time, I am asking that my client be allowed to withdraw his plea. I did submit a written motion that I amended and submitted to the court. I did not get a response from the people on the amended motion and brief. However, my argument is basically that my client was not afforded effective assistance of counsel, which is a right of his under the Michigan Constitution. His counsel, according to the transcripts, even admitted on the record that she understood my client's defense, but didn't understand how to defend it at a trial. My client's confidence in his attorney at that time, and probably before he had to take the plea, was shattered, and he did not feel confident that he had sufficient counsel. He did not take the plea knowing, and because he did not take the plea knowing, he did not take the plea willingly. He did not know the effects that the plea would have. He did not know at the time that it would keep him from being able to get a medical marijuana card. He did not know at the time that it was the prosecutor's burden to prove that he was operating the vehicle. He wasn't explained that by his counsel. And
I explained that to him myself on the record.
He wasn't explained it by his counsel. He is supposed to get knowing a knowledge of the effects of his plea from his counsel. And so before he stood in front of you, Your Honor, to take the plea, he should have known that, one, he would not qualify for a medical marijuana card if he were to be found guilty, or the court would not recognize his medical marijuana card if he were to be found guilty of this offense. Two, that it's the prosecutor's burden to prove that he was actually the one operating the vehicle, which of course is my client's position, since he was put on the record to take the plea in the beginning, he stated clearly he was not driving. And to further the fact that he didn't know what was going on and was just going with the motions after he spoke to his counsel in a breakout room, he pled guilty to being under the influence of alcohol. And if it wasn't for the counsel for the township speaking up and saying, Your Honor, no, it's not alcohol, it was a controlled substance, my client could be in front of you, Your Honor, right now for an alcohol charge and not the original charge of operating while intoxicated from a controlled substance. So I do not believe that his plea was made willing or knowingly. And I do believe that he had ineffective assistance counsel when he did take the plea. Mr. Jones would have insisted on continuing with the jury trial, I think, if he had more confidence in his counsel. But with his counsel admitting that she did not know how to defend his defense or represent him with that defense, how is one to be confident to go in front of a jury with their defense if their own attorney is telling them they don't know how to defend them? With the jury trial, there's reasonable probability that a jury could have found that there's no proof beyond a reasonable doubt that my client was driving that car. And he has a right to that. He has a right to counsel. He has a right to take a plea knowingly and willingly. And he has a right to be informed of all of the consequences before he takes a plea.
Peeps, I was just gonna ask the same question. It sped up for about 2 seconds. I was thinking it might have just been me, but you said it, so I guess it did. All right. So far so good. The attorney's not wrong. It sounds like the defense attorney that this guy had was I don't know. I'm not gonna say ineffective. Well, I mean, yeah, if she's arguing the wrong charge, yeah, that's not a good look. All right, let's keep going.
And that was not done here.
Burnett?
Your Honor, the
Oh yeah, absolutely, absolutely. Judge Washington is not having this right now. But we've only heard the defense attorney's side right now, and like I said, if your attorney's arguing driving while intoxicated of alcohol and that's not the charge, I understand why she would file the motions that she did, but this does get a little heated here shortly.
terms of the plea and advice of rights were all plainly put on the record by Your Honor, and Mr. Jones was asked about those and stated he understood. There's no defect on its face in the plea proceedings as they transpired. So we had to take him at his word there under oath that he understood and was advised of those rights and then waived those and entered a guilty plea. Really, the case is about, or the motion here, as I see it, is about a motion to withdraw the plea, which is governed by MCR 6.130. And under that court rule, in the absence of procedural error, and I don't think there's been any procedural error shown here, the defendant must establish a fair and just reason for withdrawal of the plea. And that's the Harris case I cite in my response. And when a defendant asserts his innocence, which apparently is what's happening here, the court should be liberal in granting that request, but it doesn't need to be requested where it's obvious or granted where it's obviously frivolous. And in my opinion, this is a frivolous situation. He's entered a factual basis on the record himself. The police report indicates that the defendant admitted to Deputy Siller that he was driving the vehicle. There's an independent civilian witness who identified the defendant as the person who...
Your Honor, that's not true.
Please don't interrupt him. You can speak once he's done. Ms. Lacey.
Thank you. It's an independent civilian witness who identified the defendant as the person who had been operating the vehicle. He got out of the vehicle wearing a distinctive hoodie, went into a residence, came back out and got into that vehicle after striking another vehicle in the parking lot. So again, this is really just buyer's remorse. and that's what we have here. The Haynes case I cited in my response suggests that withdrawal is inappropriate where a factual basis is established, which we have here, and the defendant's claim of innocence is not supported by review of the entire record. I understand counsel has come forward with two alleged witnesses, one of whom I believe is the mother of the defendant, who's the essence of her statement is that he came into the residence and then left. So she's not even outside to provide any probative information as to what occurred in the parking lot. The other is a person who claims to have dropped the defendant off and then left himself somehow after driving the defendant's vehicle. And I would suggest that the credibility of that statement, given the kind of overwhelming evidence to the contrary, would suggest that if you look at the totality of the circumstances, it's really not strong evidence. So I don't believe that the defendant has met his burden of showing it's in the interest of justice to allow for the withdrawal of this plea. So I would ask you to deny the motion.
Your Honor, if I may rebut briefly, the witness that Mr. Barnett states identified.
All right, I never really understand this. Attorneys do this all the time. They'll ask that question, if I may, Your Honor, if I may, respond or whatever, and they don't wait for the judge to say anything. They just start talking. I guess it's just standard practice that she would get a chance to talk, but I don't know why you would phrase it that way if you don't wait for the judge to say go ahead or whatever. But now that I've told you guys that, you're going to see it happen a lot. Attorneys will ask for something and then just go right into whatever they just asked for.
By my client admitted to the police, and if Mr. Barnett reviewed the video, he would know this, that she did not see who was driving the vehicle. She did see three individuals, and I know Mr. Barnett is trying to figure out how my witness left the scene after dropping my client off, but his own witness that he says identified my client did say that there were three individuals, and one vehicle was being followed by another vehicle, and all three of the individuals went into the home after the vehicle struck the minivan and then parked across the street. She did admit to the police on the officer's body cam that she did not see who was driving the vehicle, and she could not make a 100% identification of the driver. So I think that Mr. Barnett wanting to use that witness, I think there's holes in her story. She was outside herself drinking in the driveway of her friend's home. She does live 2 streets over, but I think that if the court would consider the situation and the condition that Mr. Jones took this plea and the ineffective assistance of counsel he had at the time, that I don't understand, and I do not know if his counsel reviewed the video, if his counsel saw the witness wasn't as strong as Mr. Barnett would put forward here today. But Mr. Jones' plea was not willingly and definitely was not knowing. And so I am asking that you allow him, in the interest of justice, to withdraw his plea and allow him his opportunity to have his case presented in front of the jury of his peers.
Thank you. Anything further from anyone?
Not from the township, Your Honor.
All right, thank you. So a part of what happens when a motion like this is filed is basically the court gets an opportunity to go back and review the plea in great detail to find out whether there were anomalies. There were clearly anomalies. The question then becomes whether the defendant was fully informed of his rights and understood those at the time that he took the plea. And in this particular case, like the prosecutor has outlined, if there are no real concerns with the procedural posture of the case, the court has to find that there is some injustice or fairness, unfairness to the defendant based on the actual allegations of this case. And in this particular case, first of all, Mr. Jones pled on September 26th. When we look at the transcript, Mr. Jones was at one point indicating that he was not driving the vehicle. And I, at that point in time, said I was not going to accept the plea. He went into a breakout room with his attorney, who was Ms. Moeller, and they were given plenty of opportunity to discuss what his options were. He came back out. And the reason I did that is because he said, I asked, and were you operating at the time? He says, I was not. I guess I might be confused in what the process is that we're going through right now. Those are his words. I said, okay.
Stop your. Testing. I apologize. We're back on.
Thank you. And then I said, okay. And he said, but to answer that question, no, meaning that he was not driving. And I said, all right. So he's saying he wasn't operating a motor vehicle. Then his counselor says, Your Honor, I don't know if this would satisfy, but Mr. Jones was found seated in the vehicle when the officers arrived. So are we giving up the defense of any technical definition of operating? Defendant said, okay. And she wanted to proceed under that. And I said, it makes some sense to some degree, but it sounds like he's saying to me that at no point in time was he operating a motor vehicle at that particular address, 7525 Warwick Road. And then she said, could we talk briefly in a bench conference? And then I did that. Well, and then I said, are you sure you need to be talking with me and not your client? Because I don't think my position is going to change. He has to be operating at some point. And then she says, we've had several conversations. I do understand his defense. I don't know that we are going to be able to execute the defense the way that we would need to for a jury trial. That does not sound like ineffective assistance of counsel or that she does not understand it. It sounds like she does not feel as though they can actually execute it. That is a decision on behalf of counsel. That is a trial strategy or lack of strategy or whatever. That's her decision. Then I say, we do the breakout room when we come back. They were placed in a breakout room because when I come back, I say, Ms. Moeller, you were given a breakout room to speak with your client regarding his options at that time. At this time, I believe you just stated before the case was called that you're ready to proceed with the plea. Is that correct? She says, that is correct. Mr. Jones understands what that means. He will be admitted to operating and wants to accept the offer for the visually impaired charge. I said, all right. Mr. Jones, you've had a chance to speak with your attorney, sir. You understand your options, and you are choosing to move forward with this plea. No uncertainty, none. Yes, I do. And sir, you understand that means you have to admit that you were operating this vehicle at that time, if that is the truth. And you are sworn under oath. You understand that. I do understand. All right, sir. So you're still under oath. Second warning, you are still under oath. So under oath, were you operating a motor vehicle on November 4th, 2023 at the location of 7525 Warwick Road? Now, either he committed perjury or he was in fact under oath saying that he did this truthfully.
I think sorry, Your Honor.
Go ahead.
Question. Sorry.
Go ahead.
Oh, I think I did admit at the first hearing that he committed perjury, Your Honor. His back was up against the wall. He's never been in trouble. He's never been in courts before. He was uncomfortable, very uncomfortable with his counsel. And when you're back.
Yeah, that's exactly what she just said. Your Honor, my client was uncomfortable, so he committed perjury. So you should allow him to withdraw his plea. Nah, nah. You can see why I keep almost calling her Judge Simpson. You can see why she's getting a little frustrated.
Is up against the wall and you don't see any other options because you're not fully informed. As Your Honor, I'm sure knows, false confessions and pleas have been made. And this is a perfect situation for just that.
Okay. The bottom line is he said under oath that he did this. So I asked him if he understood his options. He said he did. I went over all of his rights with him. He said he understood them. He said he was waiving them. That is the choice that he made that day. It was a valid plea. If he has an issue with counsel, that's not an issue before this court. The motion to withdraw plea is denied.
Thank you, Your Honor. Can I have that in the written order, please?
Yeah, prepare it. I'll sign it.
Thank you, Your Honor.
As far as his claim that he did not understand my position with respect to the marijuana, that's not true either.
Oh, that was just one of the motions. We've got another. Is it just one more or two more? I don't remember. But yeah. You know what? Before we get into this next motion, I want to make sure to call out Rich. Thank you so much for the super chat, Rich. Collins Ethernet Cable Fund. Thank you, Rich. I appreciate it. Yeah. Got about 8 to 9 minutes before my internet decides to crash. If it's gonna happen, hopefully it doesn't. We'll see in a few minutes though. But if it does, please just be patient. I'll be back as soon as possible. Just I don't know, for the last week, every night at 8:30, my internet's just crashed for about 5 minutes. So please be patient with me. I will come back as soon as I can. Yeah, sorry guys, I didn't edit this out. I don't know what she's reading. She started talking and then just stopped.
On
There
August
we go.
the 21st, during that particular pretrial, I made it very clear that if it's a violation of the Medical Marijuana Act to be driving in the way that he was driving on that date, then I'm not gonna allow him to use medical marijuana when it's clear he's violating the act, that he didn't even have the authority at that time to be using in the first place. So he knew as early as August.
I'm sorry, Your Honor. Did you move on or are we still on the motion to withdraw?
Did I stutter, Ms. Lacy, about what I was saying?
No, you gave your ruling on the motion to withdraw, but it sounded like you were discussing more of that.
I was, and your problem?
Oh, nothing. I just wanted to, for my notes, I wanted to make sure I put it on the right form. I'm sorry. I thought you were done with the order.
Did I stutter? What's your problem? Yeah, Judge Watson not having this attorney, not having it. No, I actually ran to the bathroom. Right when right after the last time I paused, I ran to the bathroom real quick, and when I came back, I have my headphones in, so it was just completely quiet. I had no idea what was going on.
All right. Next. You want to have a bond violation hearing today?
Yes, Your Honor.
All right.
Your Honor, we're ready to proceed. I'll call Maya Dozier.
You sure you want to do this, Miss Lacy?
The bond violation hearing is still needs to be had. Isn't that correct, Your Honor?
All right. As long as you understand and your client understands the repercussions, we can do this.
We don't understand the repercussions, Your Honor. Are you threatening something?
If he's in violation of his bond at the time that he was in this situation, then he can go to jail. That's not a threat, that's a consequence.
Our position is he was not in violation and the court can't prove it.
Okie dokie. All right, Mr. Barnett, you may proceed.
Thank you. We're calling Maya Dozier.
I'm here.
All right, please raise your right hand to be sworn. Do you swear or affirm that the test?
Does anyone else get the feeling that there might be some backstory between Judge Washington and this attorney? It's like the one guy that whenever he's in front of Judge Simpson, they always have a small back and forth. You just feel like they don't get along. They don't like each other. I feel like that's going on here. I don't know. I've never seen this defense attorney before, so I have no idea. But yeah, I don't know. I'm just getting a weird feeling between the two of them.
Testimony you're about to provide will be the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may proceed.
Thank you. Ma'am, would you state your name and spell it, please, for the record?
Maya Dozier, Mayadozzier.
And ma'am, how are you employed?
I'm employed with the Washington County Sheriff Office, Community Corrections. I'm a supervision agent for Community Corrections.
Okay. And just in layman's terms, what does that mean?
I supervise clients while on bond, making sure that they abide by the conditions ordered by the court.
And how do you do that?
We receive an order from the court with conditions, whether it being standard, intermediate, or intensive supervision. And I have them come in, do an intake appointment, and assign testing, and then they test. Mr.
Okay.
Jones is testing weekly.
Okay. So, and when that's testing for, it could be alcohol, could be controlled substances, could be both. Is that correct?
Correct.
Okay. How does the testing work?
They come in, sign in, pay a fee, and then they're tested. There's a monitored testing at our facility.
Yep, it's happening. Yep, I know, Chester. You've been counting down this entire time. All right, I'm gonna wait a minute to hit the play button, guys. Hey, no, Chester. It doesn't seem to be going down for very long though. I'm still gonna wait. I'm still here. That's exactly what's going on. Yeah, I'm just gonna hold off probably a minute or two before playing. 'Cause it's my internet connection is just super low right now. I do appreciate you guys being patient with me. I'm gonna try. I'm gonna try. It's not always on me though. So when my internet, it'll just freeze, and then you guys won't be able to hear me. So right now, I think you can, but I'm still gonna wait a minute because I feel like when I rush it back, I don't know. No, it probably did. I think it went out twice. I can see it. 'Cause I'll start to get a little spinning wheel of death on my side, and when that happens, I know that nothing's coming through. That's when I paused it when I first saw it. But all right, looks like it's recovering. So, all right. All right, let's try it. Tonight would have been the fastest recovery of the week. Let's go.
And what was your understanding of what was required of Mr. Jones?
My understanding was that he was not to test for any illicit substances not prescribed to him, and that he was not able to do THC. He informed me that he did not have a medical marijuana card.
Okay, so you're testing for drugs and THC, is that?
Correct.
Okay,
And we do a PBT test for the alcohol.
okay. How often was he, when did he start testing?
Please forgive me. I don't have the file in front of me because I'm at a different location and I meant to grab it, but I didn't. But I want to say sometime in June of 2024.
Okay, and how often was he supposed to test, if you recall?
One time per week.
Okay.
They wrote it out later to be 4 times per month, which is equal to 1 time a week. So you're assigned a number. You call the hotline daily, listening for that number.
Okay, so it's random per the week, but 4 times per month.
Correct. You don't know when you're going to test. You call the hotline. If you're to be assigned a number which comes up weekly, you're going to call the hotline every day as early as 5 a.m. and you're going to listen for your number. If your number is called, you have to report to community corrections that day before we close.
Okay, and when the person, in this case, Mr. Jones, his number was called and he reports to community corrections, what does he do at that point?
He reports to community corrections, signs in at the front desk, and then he's called by one of our drug testing agents who go into the restroom with him to monitor his drop.
Okay, and it's a urine sample that's taken, is that correct?
Correct. They do a blow test first, a PBT test to check for alcohol,
Gotcha.
if they have been drinking right now.
Okay. And was Mr. Jones compliant with coming in to test?
Yes, he was.
Okay. Were there issues with the test results?
Yes, he was positive for THC from the start of his supervision, which again, I believe to be in June of 2024 up until October 28th of 2024. All of his tests were positive. Then thereafter, up until now, they have been negative.
Okay. So when you get someone and a result comes back positive, what are your steps?
So what happens if they're told in the restroom after they sign a chain of custody that they will only receive a call if there's a positive result. So once the lab runs the test, if the test is positive, then they'll give Mr. Jones a call and let him know that the test was positive.
Okay. Did you have any of those conversations with Mr. Jones?
I did. I reached out to Mr. Jones and I asked him if he had acquired a medical marijuana card, and at which time he told me he had not. And at that time he was warned and counseled against further missed tests. That was, I believe, in August. The test, as I mentioned before, continued to be positive up until October 28th, I believe, was his last positive test. And again, each test thereafter has been negative.
Okay. And so the report that was issued on October 28th would reflect those positive tests in the month of October. Is that correct?
Correct. And anything prior.
So would that have been, and just focusing on the month of October, that would have been 4 tests that were positive for THC?
Correct.
Okay. And how is it made? How is the determination made that a test is positive for THC?
Well, it's ran on our machine. I can't really get too much into how the machine works. That would be for our drug testing coordinator, Michael Soshi. I know that they do run the test in-house, and it determines a positive or a negative. We don't do levels. If the client wants to contest the result, they can have it sent out to our other lab, and it would confirm or deny the positive.
And would that give a reading as to levels as well?
That part, it would, yes. They know that, and they're informed once they're testing, when they go over the chain of custody, that there's a $30 charge, but that is only if you contest it, and you have to report I believe within 48 hours of the positive call in order to have that sample pulled and sent to our other lab.
Okay, and so that information was conveyed to Mr. Jones at the time he
Yes.
was tested?
It
Did
should be explained every time in the restroom when you're going in at the time that the drug testing agent is monitoring you. They go over the chain of custody each time a client is tested.
Okay.
And then they sign the chain of custody when they submit their sample.
To your knowledge, did he ever request that the sample be sent to the other lab?
No,
Okay. And you said so he had at least 4 tests positive in October, and the last being October 28th. Is that your testimony?
I'm not looking at the report right now, so I'm not sure if it went beyond the 28th because October has 31 days. But to my knowledge, I don't believe he missed any tests.
Okay.
But I do remember, I want to say that the 28th was positive in the
Okay.
last test.
And the ones prior to the 28th that were in October were also positive.
Correct.
Okay. And then you said he's continued to test after that time?
He has.
And have there been any positive tests after that time?
No, there has not.
Okay. And when you get a series of positive tests, what are your steps in terms of the court?
I write a violation report.
Okay. So did you write violation reports with respect to Mr. Jones?
I did.
And how many, if you recall?
I believe I want to say a total of 2, maybe 3. I'm not 100%.
Okay. Did you write one on August 20th? Does that ring a bell?
It does.
Okay. And did you subsequently write one on October 28th?
Yes, I did.
Okay. And those just relay the information that there's positive tests to the court. Is
Correct.
that right?
Correct.
I don't think I have any other questions for you, ma'am. Thank you.
Thank you.
Lacey.
Ms. Dozier, do you run the test on the samples that are given?
No, I do not.
You do not.
No,
Ms. Dozier, do you have a medical background?
I do not.
Do you have a science background to decipher the tests?
No, I do not.
Do you know how the machine that is used to take the test breaks down because I don't have a medical background, but breaks down the person's, the test subject's urine to determine whether or not it's positive for THC?
That I do not know. I'm not 100% familiar with the testing. I used to be a drug testing agent when I first started at the sheriff's department, but that was years ago. Again, those would be questions for our drug testing coordinator, Mr. Michael Soshi.
So it's your testimony today that you yourself didn't run the samples that Mr. Jones gave? And
samples, no.
Go ahead, I'm sorry.
I did not run the samples, no.
And is it your testimony today that you do not know how the results are compounded by the machine?
Correct.
Your Honor, I'm going to object to Ms. Dozier's testimony as far as the positivity or negativity of Mr. Jones's results. She doesn't even know how the machine manufactures the results. She did not administer the test for Mr. Jones. And under the best evidence rule, I think that we should have the person that took the sample, the person that understands how that machine works. And as far as Ms. Dozier having any information on how long marijuana lasts in an individual's system, I don't think she's qualified to answer that question either.
We can't really say for certain how long marijuana stays in
Ms.
a person's
Dozier.
system.
Ms.
Yes,
Dozier.
ma'am.
Sorry, ma'am, you can't testify right now.
Okay.
Thank you. Mr. Barnett, response?
Your Honor, I certainly, I think can lay a more sufficient foundation for her to testify as to the at what she's testified to so far. I don't know that the best evidence rule is what really is applicable here. I think it's has a sufficient foundation been laid for her to testify as she has, and I can ask some additional questions if Your Honor wants.
I don't think I need that. I think the foundation has been laid for her to testify that she has reports that came back that it was positive, but they're challenging the positive. They're challenging whether those are accurate or not. And she can't testify as to the accuracy of them as to any lab results or lab reports. It doesn't sound like she's qualified to do that. So I think that's where the challenge lies. Am I correct, Ms. Lacy?
That's correct, Your Honor.
So I think that's what they're questioning. I mean, she can come in as the community corrections personnel and say, these are the tests we do, and these are the results we got back, but they're challenging it from a medical standpoint. And so, I mean, I can receive that, but when it comes to the medical challenge, I still have to accept that she's correct. That Ms. Dozier can't testify as to that medical part.
Understood. I wonder if we could counsel and I approach briefly.
Certainly. The 14B District Court is now back in session. The court.
All right, that was about if I remember right, about a 20 or 25-minute bench conference. I really wish I was a fly on the wall to hear what they were discussing in there. All right, let's keep going though. We're actually kind of getting to the end of this one.
What will we call the case of the Township of Ypsilanti versus Nicholas Jones, 2014-00166.
Paul Barnett on behalf of the township.
Gabriel Lacy on behalf of Mr. Jones. Your Honor, thank you for that time with my client and for the conference with you and Mr. Barnett. At this time, I am going to ask the court for a bit of grace. And
you're going to ask the court for a bit of grace after you made the decision you did and found out you were losing. Like, yeah, can we take back everything we just did? Sparkle Potes, yeah, it's just a breakout room. They just all go into their own breakout room. That's how they do it.
If the court could schedule that second date, however, if within 7 days, my client has a few more questions, and I don't want to waste the court's time. If we could let the court know within 7 days whether or not we're going to proceed with that second hearing, I would like to be afforded that option. Because if we're going to take the plea, we can just get a sooner date on the schedule for him to go ahead and plead to the bond violation. But there are some questions that I still need to answer for my client. If the court would be gracious enough to allow us that.
March, does the next date, because I think you said you couldn't do March 4th. Is
correct?
That right?
Yes.
So next date would be March 18th. Does that work? Where are we at with that day? Are we here then?
All right, so they're talking about a second hearing. What I imagine happened in that breakout room is they're trying to figure out a time where they can actually get the expert witnesses in to this hearing. So they weren't subpoenaed today, so they're gonna kind of put a timeout on this hearing and call it back up in a couple weeks when they can get those witnesses. And that's what I'm guessing is going on. But what the defense attorney just said is he may take a plea deal on this before, or he might say he did this before we finish this hearing. I think she knows she lost. I think she was really just hoping that the plea would be reversed and that this hearing wasn't going to happen, is what I'm going to guess. But I don't know. Okay, let's finish it up.
I'm sorry. All right. We'll go with March 18th. Please tell me that works with your calendar.
That works, Your Honor. Yes.
And we're going to make it at 11 a.m. because like every Tuesday, it's a long docket. And that will also be, so we're not going to change that date because that's also going to be his sentencing date. So one way or another,
okay,
we'll be proceeding.
Okay.
And Your Honor, just so I'm clear, that's not the date for the evidentiary hearing.
No,
continue?
it's both. It is both.
Okay, so I
It's
should have
evidence
witnesses
hearing,
available.
and she's gonna let you know in 7 days whether
Gotcha,
Yes.
okay.
Yes.
Understood. I'm glad
I will send an email to the court and to you, Mr. Burnett.
Okay, thank you so much.
So the bond violation hearing is going to continue if it needs to continue on that date. And then we will also have the sentencing on that date. In the interim time period, your client needs to contact the probation department so we can have his probation interview.
Thank you. Will do, Your Honor.
Do you have the phone number, Mr. Jones?
No, I do not. I'm gonna grab a pen real quick.
Whoever was asking what books were behind him, you have your chance. Pause it and zoom in right now.
Okay, I'm ready.
734
734
483
483
7336.
7336.
Correct.
Thank you, Your Honor.
Thank you. We'll see you then. Yes, sir. You have another question.
Yeah. There was something about a failure to appear to a
Yes.
what was it? Um, I think like my registration or for my car registration.
License plate, yes, registration. You failed to appear on August the 15th of 2024, and a bench warrant was issued. He needs to be arraigned on that bench warrant.
Is he still able to go on the court website to set up that arraignment, or do we need to work? Okay.
24S 442 5020.
20. Okay, thank you. We'll get that taken
No,
care
no,
of.
that was the offense date. I'm not sure when the bench warrant was issued. But that was the, I'm sorry, what did you say? Okay, 1 second.
While there's this little break, Derval, I'll explain what jump
It
kick
was just
backflips
issued
are.
on January 30th.
I'll explain what the jump kick backflips saying came from after this hearing. So you got about 5 minutes, and then I'll tell you the entire story just for you.
Oh, it says that right there. I kept reading the note. January 30th, he failed to appear for the pretrial.
Oh, okay.
I'm trying to find the I have all my mails from court, and I don't have anything like regarding that.
We'll sort it out, Mr. Jones. We'll get you arraigned and we'll get it sorted out.
Okay. All right. Thank you.
Thank you, Your Honor.
You're welcome. I guess you don't need that.
All right, and that's it. That's it. Yeah, like I said, I really want to know what happened in that breakout room because everyone's attitude changed when they came out of it. There was I feel like they were like butting heads, and then they come out, they're all, hey, no, I'm not gonna say what I was just gonna say. All right. Derval, you've asked this multiple times over the last couple of weeks, and I keep promising that I'll tell you the story, and I just never did. So here we go. Jump kick backflips. Back when, I don't know, early 2000s, Xbox 360, the original Gears of War came out. I played a lot of Gears of War, a lot of online multiplayer, and there was I don't know, a move, a technique. It was called a two-piece, where in the game you could melee somebody and it stunned them for a second, and then you could shoot them with your shotgun and just blow them away. It was called two-piece. That's what it was. And I coined the phrase jump kick backflips because you would do a front roll to get close to somebody, and then you would do the two-piece, and then you would roll backwards to get away from the rest of their team. So instead of calling it a two-piece, I just got creative with it, and I would just say do your jump kick backflips, as in, when you roll forward and roll back. So that's where it comes from. There's probably only 3 or 4 people left on the planet that actually played with me in that game that would remember that. So now you know. Now you know the story. It's just something personal. I think everything that I do, those little weird things I do, pretty much everything comes from gaming. So there you go. There's the story. Not the craziest story, but Yeah, you've asked a lot, so there you go. All right, we're moving on. We're moving to Texas. Well, yeah. Let's just go. You guys are awesome.
I've already made up my mind, ma'am. Thank you so much. You have 21 days to appeal.
So she,
Cause number, ma'am, you're excused. Cause number 41S24000626. Donald Springs versus Brianna Mitchell.
So what do we do now? She awarded. Okay. But if you don't like that outcome, you have 21 days to appeal, and they can give you information like the. But now we can. If you want to appeal, yes.
No, it was the forward roll. So when he rolled forward, that was what I said jumping was. And then the backwards roll was, so you would jump forward and so jump kick backflips. So jump kick would be the forward attack, and then the backflip would be rolling backwards. So yeah, no, there was absolutely no jumping, and didn't say that it made a lot of sense. I used to call it the reverse dragon roundhouse kick, but that was just too much to say, so I had to stop doing it.
Thank you. Y'all have a good day. All right. So tell the court why we're here today. Looks like you bought a 2016 Mazda. Sorry.
Yes, ma'am.
Okay.
Her and my wife was talking, and I overheard him that
Oh, Grandpa talks really low, guys. So you might want to turn your volume up. He doesn't get any louder. It's Grandpa. He's just a low talker.
we were motoring in the car. And, so she was going to try to get another car.
Okay.
So she said that I overheard her talking to my wife that she was going to go to the dealer and they was going to give her $500 for the car without the motor because it needed a motor in it. So
yes,
I explained to her that they were going to give her $500 and they're going to just take and fix the car back up and sell it again. And so I offered her $1,000. She agreed to it. And I took the car. Me and a friend of mine, we went and found a motor for it. And I got all the other parts that I was needed for it. And I fixed it back up. And so it was running. And she called me. I went and picked up my wife from dialysis one morning. And she told me, well, we didn't want to buy the car back. And I didn't say anything. So I got home. I called Bree and I asked her, what's up? She said, well, I want my car back. I said, well, there wasn't an agreement that we made. My wife was sick and she wasn't able to travel and she didn't have all her stuff for documents to travel. So I was getting the car so I could, go short trips with her. And she passed away January the 2nd. And that was the reason. And I did a lot, she had lived with us, her and her son, for 2 years. I was asking her, I said, well, you can give us $250 a month, which comes out to $3,000 a year. So she said, well, I give you $1,800 when I get my income tax check. Now, when she moved with us, the car was behind on the payments. And I have a Kia already, and I thought it was, when it came in the mail, it was for her car. And I guess you got it from the Kia motor vehicle place. But she was behind on it, so she was staying with us, her and her son.
and is she related to you, or how do you know
This
her?
this is my granddaughter.
Okay, there you go.
And she's been in and out with us. We practically raised her and her son, and I was trying to help her. And they offered her like $500 for the car. And I told her over and over again, why don't you get the car fixed, get the motor for it, and whatever parts you need. She said, no, I don't want the car. So I even took her to go look for a car. She drove a Lincoln one time, me and the
So why
salesperson.
are we here? What do you want the court to do? I'm
Well,
confused.
I was trying to get the license, I mean, the registration and stuff. The car been sitting at my house over 2 years, you know, and I can't even drive and I got it fixed, you know?
Okay. So you want the title and the registration.
That's what I would like.
All right.
All right. That was a long way to say that he's just looking for the title and registration. All right. I'm going to try to summarize what he just said, what the case is about, since he's talking so low. Grandpa bought his granddaughter's car off of her. So whatever was something happened to her car, she couldn't afford to get it fixed, but she needed the car. So Grandpa bought her car off of her for I think did they say $1,000? I don't know what they said, but um, so yeah, so it's essentially it's his car now. It's his car, but granddaughter doesn't really think that. She thinks it was more of a loan, and it wasn't really, she didn't really sell it. We're about to get to her side in a second, but Grandpa's trying to get it registered. So in the meantime, he's got it fixed. So the car is running now, and but he can't drive it because she has the title, so he can't register it. So that's what's going on. So he took her to court so he can get the registration and title from her because she's not giving it to him. All right. I feel like I just spoke as long as he did.
So initially, when my vehicle did go out, at that point, I was not staying at the house anymore. I had moved out and
That doesn't matter. Where's
Well-
the title and the registration? Because he bought the car for me for $1,000.
it's still under my name. We couldn't go get it because like he said, my grandmother didn't, was not from here. So her birth certificate, all that stuff, it was a whole thing with the,
Well, if the car's in your name, it doesn't have anything to do with his wife. So
no, she's on the title with me. She co-signed. So when we went up to the title office beforehand, before all this, we did all of this. We talked this, my initial goal was to get a payment plan with him to help me fix the car because I cannot afford a car payment. I just had a car repo that I had to get in order to have a vehicle because I can't afford the car payment anymore. That was the whole initial thing. I wiped out my savings, which I didn't want to do, getting the vehicle, and now I'm in a bigger hole again. So that was my thing in the beginning with the car initially. I wanted to work out a payment plan with them to get all of that so that way I could keep my car because that car is paid off and all I have to worry about is insurance and maintenance.
saying he paid $1,000 for it.
Yes, so we still tried to
Bought
go.
the car from you, so
Yes,
it's no
ma'am.
longer
So we
your
still
car.
tried to go, it's parked at their house, but we still tried to go up to the title. We couldn't do it because she didn't have the license information. So they told us at the title company, since she's on there, I cannot get the title by myself.
Now
She
she's
needed
passed
to do
away.
it.
So now, did you go back to see what you can do?
No, I still need a death certificate. I don't have that. He has that. I mean, I don't know how that works with death. I'm pretty sure they'll take the death certificate, but she just passed on the 2nd.
Okay.
I do not have
So
that.
do you have a death certificate?
I have this too.
Okay, then I'm gonna reset this for y'all to figure this out. You need to take
Wow.
that and down and get that and put it in his name then, if he paid you
Right.
for it. If not, then the court will probably have you pay him back his money.
That was the initial plan because I cannot afford another vehicle. He has a vehicle already, he has her vehicle, and I just wanted help to fix mine. So technically right now, there's 3 vehicles sitting over there at his residence and I don't have a vehicle. So I need this vehicle for work. I have a cleaning business.
You sold it to your grandfather.
I know, and I was trying to buy it back from him because I was still
Okay.
borrowing her car in this. He even offered to
Ma'am,
switch her
You
car.
sold it to him. so
That's fine,
he
ma'am.
needs
I will
the
pay it
title.
back.
No,
I cannot,
you
I don't have the
sold-
death certificate.
You
I
need
don't
to
have
calm
the
down.
death certificate, ma'am.
You need to calm down. You sold the car and you just want it back. That's not how things work. All right? You sold it. He's entitled to the title. So you need to figure that out. And I will reset it for you to figure it out and give him the title to the car. So
That's
he can get
fine.
it registered.
That's
And then
fine.
y'all can figure it out from there.
That's fine.
He seems like he's helped you a lot. And you seem very ungrateful.
We have, my wife. and I
Yes.
did a lot.
So I'm resetting this for you to get this title figured out and give him the title. And then from there, y'all can figure it out. Okay? Y'all are excused.
Thank you.
I'm resetting it for 30 days.
Yeah. Yeah, she doesn't know what sold means. You're absolutely right. I don't. I guess she was just expecting the judge to be like, "Oh, you have 3 cars, so just give her car back." No, it doesn't work that way. Doesn't work that way. Also, someone said who passed away. It was her grandma. Her grandma was on the title of the car with her, so I don't know why she needs a death certificate for that. She co-signed on it. She's just a co-signer. I mean, the death certificate you could take her off of it, but I don't know what that has to do with transferring it. You might need. Yeah, maybe you do need it to transfer it. Anyways. Also, someone asked what judge that is. I don't know her name. That is Judge Garcia's court, and she is a pro tem judge that sits in for Judge Garcia when she's not there. But Judge Garcia, that happened this morning, and Judge Garcia was there this afternoon. So yeah, I don't know. I don't know what her name is though. All right, we are gonna move to the last one. Yeah, last case. Before I do, Sparkle Poots, thank you so much for the PayPal. I appreciate it, and I'm not gonna jinx it. Not. It's kind of late now, but Sparkle Poots, thank you so much for the PayPal. All right, last one. Trying to remember I don't remember where we're going.
We have 2 matters.
Oh, we're staying in Texas. Okay, this is Judge Holmes, and she generally does eviction docket. Now, this is the reason I put this on here. Well, it's not really a defendant in a landlord tenant case, but the lady, bottom left corner, I covered about a month ago. They're going to talk about the hearing here. It's when she got evicted. She got evicted. She went complete Karen on the court, and the judge, the landlord, she was a menace to the hearing. And I saw her, and I'm like, oh, this is going to be good. But yeah, no, she's changed a little bit. She still seems a little entitled for what she's asking for and how she acts, but no, she's actually fairly pleasant in this hearing. But I just wanted to throw this up here because yeah, she doesn't go full Karen in this hearing.
Left. So let's move into these. Now these are not. I think these are both writs of retrieval, bit of reentry.
Yes, one is reentry, one is a retrieval, and we did have the plaintiff for case ending in 322 show up. And
No, I watch so much court on a daily basis, so many videos, so many live streams. Or I could black out and think it's last week. I mean, I wouldn't be surprised if that happens to me at some point. But no, never know where I'm going.
I was able to check him in.
All right. Well, let's do 25321. That's the older case. This will be Stephanie Ramirez Morphin versus the Cliffs at Barton Creek. Do I have Stephanie Ramirez Morphin?
Yes, I'm here.
Good afternoon.
Hey, how are you?
I'm just fine. All right.
Good. I really like your Kendra Scott earrings. They're giving like an iridescent effect.
Hey,
it's cool.
That's why I like them, because they match everything.
Yeah.
Right? Like they do. I dig it. All right.
I love getting their like happy birthday discount. They do half off on your birthday month.
I like how many people have told me I should sign my husband up and then buy jewelry with his birthday in February. No joke, Mary.
Yeah.
It's a gift to him if I look nice, right?
They do check IDs. Just bring him.
Good to know. Good to know.
I got you.
Got a whole fake ID market out there. It's not because people are trying to drive. It's because they're trying to get their Pinterest Scott discount. So, okay. All right. Well, thank you for being with us. Ms. Ramirez, let me go ahead and swear you in. If you'll just raise your right hand and state your full name for me.
Stephanie Ramirez. Morphine.
Do you understand by a period in court, you're swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury? Do you so swear?
I swear.
Fantastic. All right. Tell me where you live.
I live at Bell Lake Shores. I just recently moved from the Cliffs. It's over in Riverside.
Okay, no, that's fine. All right. How about the place that you're trying to get back access to? Are you still currently a tenant there?
No, ma'am. My lease ended in October, but I left a box there, so they stated I abandoned.
Yeah, that's exactly what I was thinking. Who gets a fake ID to drive? No, you don't get a fake ID to fool a police officer. You get a fake ID to fool the kid working at the gas station to buy alcohol from. That's why you get a fake ID.
The unit, and they were billing me until December. But I'm going through like a lot of cases with them right now.
I'm not going to be able to give you a writ of retrieval for that. If it's been that long, what are they trying to get back?
It's a box of kitchenware, And I read online that I have a month to get things back. So if under the law, if they stated that I have moved out in December, I'm still within my right. And then I went in person, and they mentioned it in the email threads of the eviction services, but I went in person. Well, I tried to call.
Let's get a timeline down. Okay. You had a lease at the Eclipse. Correct?
Yes, from October of last year to October, well, 2023 till 2024.
When have you returned the keys to the landlord for that unit?
Yeah, the day of the end of my lease of October.
When did you return the keys?
I think it was the 30th of October, but they stated I didn't move out until December, until I gave them work.
Just answer my questions for me, right?
Okay.
I don't care what they told you. I got to figure out if legally you have any right to still be in this unit. You returned the keys to them October 30th.
Yes, ma'am.
Okay. And at the time you returned the keys, you were aware that your stuff was still in the unit.
Yeah, I had realized that I forgot a box, but I just didn't know how to.
When did you realize you had left the items there?
Literally the next day. I thought my friend that I stayed with had kept the items.
All right. And when did you contact the landlord to retrieve that box of items?
In December, once they told me that I had been abandoned it.
Ms. Ramirez. So you moved out and gave them the keys October 30th. And the following day, November 1st, you realized you'd left some items, but you waited a whole month to contact the landlord.
Yeah. I was scared to contact them with the case and everything.
Please go research your rights as a tenant, because I'm afraid that I can't give you anything today. But I'm going to suggest that you contact the law library and look at small claims information. That might be something you would want to research. But I can't give you a writ of retrieval this far after the fact, when you voluntarily returned your keys and maybe unintentionally abandoned some goods there. You might want to look at small claims lawsuits against a landlord if you believe that they have improperly destroyed or otherwise gotten rid of items of value to you.
Okay. I mean, I did go in person, and they only gave me a few items in hand, but I know they kept the more expensive items.
I can't legally give you a writ of retrieval for those items today, but you have what's typically under Texas law. You have 4 years if you believe that someone has breached a contract with you. If you believe the landlord erred in removing or throwing away or getting rid of your items, that would be something you might want to research, a breach of contract. And you have 4 years to do that. So if you just moved out this past year.
Does anybody else love it when a judge says, I can't give you legal advice, followed by legal advice? I mean, I love Judge Holmes. She's awesome. And judges will do this, but I just think it's funny. I can't give you legal advice, but you should sue your landlord in small claims, not here.
You have plenty of time in the next weeks or two to look into that. Technically, you have 4 years, although I'll just say legally and for most courts, the sooner you look at it, the better it is. Typically, because people's memories are better. And if it's a landlord, they might have had changeover already. But that would be where I would if you want to look at two places, TexasLawHelp.org is a good resource for that. What to do if the landlord throws away your items. That's one. And then here locally, the Travis County Law Library, if you are interested in learning what to do or you need help with forms, they're a really good resource. And both of those are totally free. The Texas Law Help one is completely online. Small claims is what that is. And in Texas, you have 4 years to pursue up to $20,000 of loss.
Okay, I'll look into that. Thank you.
All right. Ms. Ramirez, good luck. And look into what to do as a tenant if you, in that little bit of interim, even if you've had a bad situation with your landlord, you have rights to get your property back, but it really quick. Okay?
Okay.
Okay.
I'll be efficient. Don't worry. Thank you.
All right. Go look into those things for you, though.
Yes, ma'am. I took notes.
All right.
Thank you.
Good luck. Thank you. I like your shirt. You look really good.
Oh, thank you. They're a band. Right. You should check them out.
Don't leave jewelry in apartments, because I definitely think that would.
Yeah. No, I've had roommates even take things from me, so I don't deal with roommates anymore.
I used to work for the University of Texas, and I dealt with a lot of students that moved out at the end of every year, and there they rent by the bedroom, right? So like you rented bedroom A and I'm bedroom B and Mary's.
Yeah,
bedroom
exactly.
B. Well,
Mhm.
you and me renewed, and Mary didn't. Well, they came in to clean the room and they actually thought it was me and they threw all my stuff away.
Oh my
They threw
God.
away every single piece of clothing this young man had, including 5 pairs of Air Jordans.
Was he able to get anything back through like the
Oh yeah, we
civil
got a big
court?
old. There's absolutely no reason to believe that the landlord understood. Like they made a mistake. There's no possible way he
Yeah.
thought this apartment was abandoned when he has a lease that was signed a renewal. That was a mistake of fact by the landlord who
Wow.
absolutely just looked at the wrong. Like they looked at the layout and the maintenance guys went in the wrong bedroom.
Oh my gosh.
Not an intentional mistake. They made a mistake.
Yeah.
A mistake that this young man came back from 2 weeks of summer vacation with his parents to discover that his entire college apartment was like he thought he'd been robbed, and then we were like, no one
Yeah.
they rob you.
That's horrible.
Better yet, the roommate that hadn't renewed, the one they were supposed to do, we went in his apartment. It's just filthy with all the trash he left behind.
My God.
So the landlord apologized, like there wasn't any, like they made a mistake, and you know, landlord that the maintenance guy wasn't out to like steal. They just kind of blindly doing things at the end of the summer, and I know y'all. All right, Mr. Ramirez, good luck.
All right. Yeah, that's it. That's all we got. There's about 30 seconds left of this. But yeah, I just wanted to show that. I meant to go back and find the clip of her being a Karen and kind of clip snippets out to give you a taste of how she treated. I don't think it was Judge Holmes. It's the same courtroom, but I think it was someone that was sitting in for Judge Holmes that day. So I feel like Judge Holmes would have remembered her. Anyways, thank you guys so much for hanging out with me tonight. Let's see. Thank you guys for the super chats. I do appreciate it. Sparkle, thank you for the PayPal. What else? What else we got? Don't want to say that. Yeah. All right. So that's it. That's all I got. We're gonna raid someone. Let's see. Let's see. Let's raid somebody. Let's see. KFR, KDZ, and Lone Wolf. We did Lone Wolf last night. So KFR and KDZ, it's the same show. Let's do KDZ. She usually doesn't have as many as KFR does, so we'll go to KDZ tonight. All right. Well, you heard it. We have KFR, KDZ, and Lone Wolf. They're all live right now. So yeah, we're gonna head over to KDZ. So jump in there and tell her I said hello. Yeah, that's all I got. I will see you guys tomorrow night. Until next time, bye.
I hope you are able to, if nothing else, go in and read what I'm saying about what to do in that situation when you're moving out if you discover some things, because there is stuff, but it's a little bit closer in time, okay?
Okay. Would you suggest if I get like a lawyer too?
I wouldn't suggest anything except go and educate yourself first. Whether you think a lawyer is useful or hiring one, I don't find you don't need a lawyer to be successful in small claims. Certainly you can get one, but my advice is simply go in and learn more about the framework of what your situation is.
Okay, yes, ma'am. Thank you so much. I appreciate y'all's time.
Good luck. We appreciate your time too. Thank you very much.
Thank you. Take care. Bye.
All right. That's going to be a denial though, Mary.